I don't know if I'm looking for Kayla to see. Are we ready? Okay, welcome everybody. Welcome. We're getting ready to get going. I'm going to give you an announcement that I'm sure you have not heard before, so listen closely. On CLE, for those of you who are pursuing CLE, we remind you that to get credit, you need to sign in and out each day, once per day. Signing in and signing out can be done via the scanning the CLE QR codes. Thus, if you're pursuing CLE and you have not checked in, please do so to scan this QR code on the back of your convention booklet or on the CLE poster. If you have already checked in via the QR code, however, there is no need to recheck in. Now, a second new announcement, which really may be new to you today, that's on the getting to the dinner tonight. So listen up. If you have tickets for the Antonin Scalia Memorial Dinner, this is a brief reminder that we are at a new location. As I think some of you heard Dean say, we're at the Washington Hilton. We're not at the train station. Shuttle buses to the Hilton will be available starting at 5:15 and running to 6:30 every 5 minutes. Pickup will be on DeSales Street on the side of the hotel. Further details concerning transportation are in your convention booklet or in the app. So, third announcement is welcome to this panel. I'm Bill Saunders. I'm the chairman of our Religious Liberties Practice Group. I hope many old friends here, but anybody who's new and not involved in the practice group, we welcome you to get involved. You can speak to me, you can speak to Nate, or you can speak to this gentleman over here, Michael Moreland. Hold up your hand, Michael, who's the vice chairman of the practice group and is the incoming chair of the practice group. So next year, he'll be up here speaking to you. But if you're interested, we welcome you, and we have plenty of work to do, as Michael can tell you. So now I'm going to turn the whole event over to our good friend and distinguished judge of the Fifth Circuit, Kyle Duncan.
Thank you. Thank you, Bill. I am honored and delighted to moderate this wonderful panel. We will be discussing two decisions from the 2022 Supreme Court term that address religious liberty and speech in the marketplace and in the workplace. Just a few brief remarks, and I will introduce our all-star panel. The first case we'll be discussing is 303 Creative versus Alanis, which sustained a free speech challenge of a Christian marriage website designer to a Colorado public accommodation law that she claimed would have forced her to speak about same-sex marriage in ways that violated her conscience. The six-justice majority by Justice Gorsuch situates the court's decision within the line of famous cases like Barnett and Dale and Hurley that vindicated claims by plaintiffs who were forced to speak or associate in ways that violated their consciences. By contrast, the three-justice dissent by Justice Sotomayor took a diametrically opposed view, accusing the majority of allowing a spurious speech claim to validate discrimination against a protected class. The second decision, Groff versus DeJoy, is much less controversial, but nonetheless significant. It was a unanimous decision that was effectively a cleanup operation to clean up a longstanding problem in the court's Title VII jurisprudence. The case involves a Christian mailman who sought from the Postal Service a Title VII accommodation allowing him not to work on Sundays. The issue was what showing an employer had to make to deny such an accommodation under the statute. Was it, quote, an undue hardship, as the statute itself provided, or mere, quote, de minimis cost, as lower courts had held for years based on one sentence in a 1977 Supreme Court decision called Hardison. The court unanimously clarified that the proper test is what the statute says, an undue hardship. But applying that clarified test in future cases, of course, is another matter, and one the Supreme Court has left to the lower courts to develop, which we always appreciate. To discuss these two important decisions, we have assembled, as I said, an all-star panel, an extravagantly well-qualified panel that I will briefly introduce here, although I could say much more about them. First, to my left, Ms. Erin Hawley, who is serves as senior counsel to the appellate team at Alliance Defending Freedom. Before joining ADF, Erin practiced appellate law at some of the best law firms in the land. And she has litigated extensively before the U.S. Supreme Court. She has worked in the Department of Justice as counsel to Attorney General Mukasey. She has also been an associate professor of law at the University of Missouri Law School, where she taught many classes. She is a frequent commentator on legal issues in all the best publications in the land. And she formerly was a law clerk to the Chief Justice of the United States, Chief Justice Roberts, and Judge Wilkinson of the Fourth Circuit. She made sure, she asked me to make sure to mention that she went to Texas A&M, so she could make that sound. And she got a law degree from Yale Law School, which is one of the purportedly one of the finest law schools in the nation. Okay. Speaking of Yale Law School, to her left, Professor William Eskridge, Jr., the Alexander M. Bickel Professor of Public Law at the Yale Law School. I probably shouldn't say the Yale Law School, it's just Yale Law School. I have an extremely restrained and humble description here. I'm sure I could go on forever about your publications, Professor. Your most recent book, written with Christopher Riano, is Marriage Equality from Outlaws to In-Laws, which was awarded the ABA's Silver Gavel Award for Best Nonfiction Book in 2020. We are delighted to have you here. I should mention that Erin is a late addition to this panel, and we are very grateful for you coming on board at the last minute. Erin Streett is the chairman of Baker Bott's Supreme Court and Constitutional Law Practice. He has argued in front of many of the best courts in the land, including the U.S. Supreme Court and my court, I think. I think you've argued in that court. His practice is varied and covers virtually every substantive area of law. He has argued merits cases 7 times in the U.S. Supreme Court since 2010 and has garnered numerous awards. He graduated from Hillsdale College, where my son also goes, so I appreciate that. And the university. I don't have a sound that goes with that. There is no. Well, it's the sound of serious deliberation. Touché. And free speech, I might add, which Hillsdale ranks #1 in. And the University of Texas Law School, which is burnt orange, and a good law school. You clerked for the Honorable David Sentell of the U.S. Court of Appeals for the D.C. Circuit and the Chief Justice of the United States, William Rehnquist. We are delighted to have you here. Last but not least, and also a relatively late addition to this panel, and we're grateful for you to be on here, Mr. Adam Unikowski, who is a partner in Jenner and Block LLP's Appellate and Supreme Court Practice Group, where he has worked since 2011. He served as a law clerk to the late and much beloved Associate Justice Antonin Scalia, and also the much beloved Judge Doug Ginsburg for the U.S. Court of Appeals for the D.C. Circuit. You graduated from Harvard University Law School and MIT. And you run a very, aside from your marvelous law practice, you also run a very interesting blog that whenever I feel that I want to find out what exactly the Fifth Circuit is doing wrong, I can always go to your blog.
It's a pleasure, Judge. Thank you.
And all right, I'm grateful to preside over this panel or moderate this panel, whatever I'm supposed to be doing. And so I will turn it over with no further ado to Erin. Take it away.
Thank you so much, Judge Duncan. Thank you, panelists, and to FedSoc for having all of us. So today I have the privilege of talking with you about 303 Creative. And in typical Federalist Society fashion, I have 3 propositions for you. Some of them controversial, and some of them more controversial. So first, 303 Creative is a straightforward application of the First Amendment that provides crucial free speech protections for everyone. Second, 303 Creative, while a broad ruling on free speech, is a limited ruling when we're thinking about the marketplace. It is not, as some critics have said, a license to discriminate. Third, and perhaps most controversially, standing in 303 Creative was not a stretch, but is recognized by Colorado in failing to challenge standing before the Supreme Court, and by Justice Sotomayor in failing to even mention standing in her heated dissent. I think there was absolutely a credible threat of enforcement there. So, to begin with Proposition 1, straightforward application of the Free Speech Clause. At the outset, this is not a case about LGBT rights. It's not a case about marriage. It's not even a case about religion. What this case is about free speech and about whether the government has the power to force someone to speak contrary to their most deeply held beliefs. So a bit about Lori Smith. Lori Smith is a website designer outside of Denver, Colorado. Lori Smith designs all sorts of websites and wanted to expand into the wedding business. Colorado stipulated that Lori serves everyone, including her gay clients, and she's always been consistent that she won't create certain messages with which she disagrees. She won't denigrate the military, she won't facilitate cruelty to animals, and she won't celebrate certain marriages, such as open or same-sex marriages. The record is also clear that Lori would not design these sorts of websites for anyone, regardless of their personal characteristics. So despite the sort of overheated reaction to 303 Creative, I would submit that Justice Gorsuch's opinion for the 6-3 court comfortably fits within the Supreme Court's precedents. To begin, Justice Gorsuch held that the First Amendment protects an individual's right to speak his mind regardless of whether the government thinks his speech appropriate, whether he thinks it well-intentioned, or instead deeply misguided. Second, for over 80 years, it has been a fundamental principle of First Amendment law that the First Amendment protects not only the right to speak, but also the right not to speak. The quintessential case representing this principle, of course, is West Virginia versus Barnett. Something that's often glossed over in this discussion of West Virginia versus Barnett, however, is that it overruled a case. Just a few years earlier, the Supreme Court, in one of its worst decisions, had held that a state could force a school child to recite and salute the pledge, regardless of that child's religious beliefs. There's a great quote in Judge Sutton's book that talks about one of the children in this case saying that, I refuse to do this. I would face the hellfires of damnation if I salute the flag. And yet, the Supreme Court said you have to do that in Go Bitus. Thankfully, the court reversed course in West Virginia versus Barnett, and in sort of a quote-worthy quote that we see in many opinions, I'm sure including some from the Fifth Circuit. Justice Jackson wrote that there's no principle greater than that no official, however high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. In other words, you have the right both what to say and what not to say. Nor was 303 Creative the first time that the Supreme Court has addressed the intersection between the free speech clause and public accommodation law. In a case called Hawley, the court addressed just this dynamic, and in a unanimous opinion written by none other than Justice David Souter, he wrote that an important manifestation of the principle of free speech is, again, that one who chooses to speak may also decide what not to say. So a unanimous court in that instance said that a state public accommodation law cannot compel a parade to allow a message that would be contrary to its own. Finally, the Supreme Court in 303 Creative rightly acknowledged the public accommodation laws have a long and noble history and much to do today as well. However, under that decision, under the 303 decision, the Supreme Court was crystal clear that its decision applies to speech. A lot of the detractors, including the dissent, posit that the 303 Creative decision endorses a right to discriminate based on someone's characteristics. With all respect to the dissent, the majority opinion says nothing of the sort. In 4 or 5 different places, including in the first few lines of that decision, the court goes out of its way to say ordinary commercial transactions are not affected. What is at issue is speech. We're talking about the free speech clause, and the government has no right to tell someone what to say, regardless of what they think about the content of her speech. So first proposition, straightforward application of First Amendment law. Second proposition, the decision is a limited one when it comes to the commercial marketplace. And you don't have to take my word for this, or more appropriately, the word of Justice Gorsuch speaking for himself and 5 other justices. The New Jersey Attorney General's office recently released guidance, so has the Attorney General's office in Nevada and other places. And what that guidance says is to, again, quoting the opinion, that state civil rights laws still apply to a vast array of businesses selling innumerable goods and services. So where 303 Creative applies, where the rubber meets the road, again, is this question whether speech is involved, whether something is A, expressive, second, whether that something that is being created is original and customized, and third, whether the declination to provide the creative service is based on the message it conveys and not on the status of the protected characteristic. So to talk just a bit about each of those things, there's a lot of debate about what is expressive and what's not expressive. And as Justice Kagan wrote in a law review article published in the University of Chicago, it can be a hard line to draw. But as she also pointed out, that line is worth drawing, because if it's not drawn, that means that the government can regulate most everything simply by calling it conduct. In this case, it's not a hard line. Lori uses words and graphics she draws with her own hands, and as the 10th Circuit appropriately found, we're talking about pure speech here. There will be hard cases, there may be wedding florists, there may be wedding cake makers, that ask the court to decide what counts as expression, but this case was not hard. Second, it needs to be customized. As Professor Del Carpenter says, when we're talking about dairy or desks or dry cleaning, we're not talking about customized services. Those things aren't expressive either. But we're not talking about the ordinary goods that we run into on a daily basis. And then third, the refusal or declination needs to be based on the message rather than on the person requesting it. And I wanted to mention here just a bit about something the dissent says. So the dissent calls this status message distinction both amusing and embarrassing. But I actually think there's a lot to this distinction between status and messages. First of all, and most importantly, as the majority points out, that distinction is actually part of the free speech clause. And why that is true is because the free speech clause does not protect a declination based on something other than a message. The speech clause applies to a message and only then. Second, Colorado has in other contexts, namely the context of Jack Phillips of Masterpiece Cake Shop fame, said that that message and status are in fact different. In that case, as many of you will recall, there had been 3 other bakers who had declined to create cakes for Christian bakers, having messages suggesting that same-sex marriage was not biblical. In each of those cases, the Colorado Commission said that those declinations were okay because they were based on the fact that those messages were demeaning to the baker. In other words, because they were based on the message and not the status. And finally, just a few years ago in 2018, the Supreme Court for the UK drew the same distinction, finding that a baker could not be required to bake a wedding cake. And in the words of the court, this less favorable treatment, the declination, was afforded to the message and not the man. So again, status message distinction has roots both in the First Amendment as well as Colorado's treatment and some international law. I wanted to consider real quickly, I know I'm running out of time here, just what a contrary ruling might look like. Under Colorado's logic, the government would be able to force anyone who speaks for pay on a given topic to accept all commissions on the same topic. As Chief Judge Tinkovich pointed out at the 10th Circuit, this means that governments could force an unwilling Muslim movie director to make a film with a Zionist message, something I think most of us would find unjust. In addition, Justice Sotomayor asserted in her 303 creative dissent that because the market is, quote, established and maintained by the state, it is a social contract, and part of that could be a legal norm of non-discrimination on, quote, any business that holds itself out ready to serve the public. That is a startling statement. In other words, as part of the social contract of having roads, of having clean air, of having those sorts of things, Americans can be compelled to say something with which they devoutly disagree. Finally, standing, I think in this case, was quite straightforward under the credible threat of enforcement. The Supreme Court looked at 3 factors quite briefly. One, the similar case of Jack Phillips and Colorado's aggressive treatment of him, aggressive pursuit of him. Second, the fact that any person can file suit under COTA. And third, the fact that, I'm forgetting the third one here, guys. There's another one as well. Third, credible threat of enforcement. Anyhow, there's a third one as well that they looked at. Oh, yes, it's an important one. The fact that Colorado had for 7 years declined to disavow enforcement. So all of these things, the court said, lent itself to standing. And to address just briefly the elephant in the room, this is not a made-up case. The facts of the case are that Lori Smith wanted to expand her wedding business, so she talked to her pastor. Her pastor said, hey, look at this poor guy, Jack Phillips. Are you sure you want to do this? If you want to do this, you might want to talk to Alliance Defending Freedom. So Lori contacted Alliance Defending Freedom, and that began this case. And again, if you look at the history of pre-enforcement lawsuits, they have been a staple of civil rights litigation for generations. And I'm running out of time, but I would just submit one of the most interesting things about this case, as pointed out by Professor Richard Ree, is that it may suggest that the sort of doctrinal lines on standing are shifting. Maybe the left is getting more hawkish on standing, and the right maybe not as hawkish. Maybe this has something to do with the current composition of the court, something to consider.
Thank you, Erin. I will then turn it over to Professor Eskridge.
Okay. You want to be startled? I'm going to startle you right now. And that is you can get your 2 Yale graduates, and we're both going to talk about doctrine. I kid you not. I agree on standing. You know, I'm a traditionalist on standing, and I think it had standing. But I do think this was a very curious case. I would characterize it somewhat differently and contrast it with both Barnett and Hurley. This is kind of a landmark Supreme Court case. I think it's the first time the U.S. Supreme Court has ever held that a sale, in other words, an advertisement for sale of a service, is expressive activity that cannot be regulated by the state. Okay? Barnett was not a regulation of sale. This was state compulsion. I'm from West Virginia. I'm totally with you on that. It was egregious what they did before. Okay. And Hurley, also, Hurley was unanimous. There was a dissent, of course, in Barnett. Should have been unanimous. In Hurley, this was a private parade. And I quite agree with the professor that, yeah, it's an expressive parade, but this could also apply to speech as well, which the court treated it as. But those are very different cases. There are some cases where the court did evaluate this precise argument, and two of them are Piggy Park in 1968, I believe, and Heart of Atlanta Hotel in about 1964. In Piggy Park, we had the Public Accommodations Law of the 64 Act being applied to a diner, and the owner of the diner, these were literally his arguments. The owner of the diner said, I cannot integrate this diner because the status of allowing black people to intermingle with white people would violate the word of the Lord as he understood it as a Baptist, a fundamentalist. And many fundamentalists still believe this. And therefore, this would not only violate my right to run my business, but it would violate the message I'm trying to send in the way that I run my diner. You can see that in Piggy Park, status and message are intrinsically intermingled, and the Supreme Court unanimously rejected all of the arguments made by the diner. Heart of Atlanta was a less dramatic case. There were more issues involved. The Commerce Clause was the main issue. But there was a similar argument made and a similar rejection on the part of the court. So this is actually a very big deal. And it's kind of an odd case. I do think they're standing, but it's an odd case because this is a pre-enforcement challenge, exactly. But it's a pre-enforcement challenge that doesn't appear to be a facial challenge to the Colorado statute. As I understand the opinion, after the opinion is issued, the Colorado statute still stands. So it's not facially invalid. So it must be kind of an as-applied challenge, but it's kind of an as-applied challenge to a hypothetical wedding ad and an undetermined complainant and lack of an administrative proceeding. Again, I don't begrudge that there can be standing. So we, for example, don't really know exactly what the wedding site is going to look like. There were some exhibits in the complaint. And according to the stipulations that the court relies on, according to the stipulations, Laurie Smith, whom I have nothing but admiration for, said we're ready to go with this wedding site, and the only reason we're not doing it in 2016, 2017, many years ago, is because we're afraid of prosecution. Immediately once we get relief, we'll put it up. Well, I looked at it this morning, and there is no wedding services offered on her website. It says, wedding services coming soon. This is November 9th. So that's kind of an oddity. Now, Erin and y'all's brief, there was mention, like, why do we want to bring a case when there's no complainant? Remember, the Colorado Commission generally waits for a complainant to object. There was no complainant in this case, though the brief darkly adverts to a man named Stewart as somebody who had made some inquiry about a same-sex wedding. Well, the New Republic, Stewart's identifying information is in the joint appendix, which was part of your petition for cert. And the New Republic's Melissa Grant actually called Stewart. And Stewart says, I'm married to a woman. I'm not a gay rights person. I'm not gay. I don't want to marry a man. I don't know what's going on here. So there is a little bit of a mystery. And I will tell you, I am a gay person. Gay people do not want to discriminate against religious fundamentalists. And by the way, I think overwhelming majority of religious people do not want to discriminate against LGBT people. You know, we don't want to impose ourselves, for the most part, even if we have a right to, on religious people. So I'm just not sure, you know, of the stakes there. And then, here's the real, where the rubber hits the road, just in terms of, not Article 3, but just in terms of, do we really want this kind of record by stipulation? And many of the stipulations are omitted by the court, I might add. to be the basis for this landmark opinion. So it would be better if we had an actual website and an actual complaining couple who actually asked for something. Maybe not exactly the same website as she designs for religious different-sex couples, but something maybe more bare bones, and they could go to the commission. The commission's main duty, and most of its cases are subject to conciliation. Is there any way that you can figure out a path forward? And maybe not. If the commission does rule, if the commission is persuaded by Justice Gorsuch, who writes a very brainy opinion, the commission would have concluded this doesn't violate our statute. Our statute does not say, whether on its face or as applied or anything, it doesn't say, it's discriminatory if it discriminates against a message that has a disparate impact. You'd have to do a lot of gymnastics to figure that out, maybe. So the Colorado Commission might have actually said, after listening to all the arguments, that didn't violate the statute. And then if they did think that it violated the statute, what kind of remedy would it issue? And it has a lot of potential remedies. And one point I would make is that I do think one of the upshots of all these cases should be that the civil rights commissions and the statutes should be amended to seek more common ground, not just through conciliation, which I think is a very useful exercise, but through limitation of remedies that can be used against people who, based upon principle, object to the application. So that's the first point, that this is a very curious case. Here's the second point, is that there's a paradox at the center of the case. Exactly as Professor Hawley said, the majority says the hypothetical violation is because of message, and you cite Barnett and Hurley. The dissent says the hypothetical violation is discrimination based on either conduct or based upon status. It's a sale, and they would cite Piggy Park and Heart of Atlanta and maybe some other cases. Well, here's the paradox. It's like the certs debate. I don't know how many of you all were old enough to remember that one. Is not certiorari, but are certs a candy mint? Huh?
The mints.
Yeah. Is it a candy mint or a breath mint? Well, the judge knows the answer to this. It's
both.
both. Yeah, he knows. Well, okay, this is what's interesting about the case. It's both. All expression is conduct, and a lot of expression does go to status. Most conduct and a lot of status is expressive. So a devout Catholic taking communion is status, conduct, and message, both in what they are aiming to express and what an outsider would intuit, okay? So this is at the heart of the case's dilemma. So for example, getting married, same-sex marriage, different-sex marriage, interracial marriage, interfaith marriage, etc. Getting married is conduct, it is status, it is expressive. And you can discriminate for or not based upon how you want to characterize that. A refusal to recognize or to deal with marriage likewise involves the interaction of all three of these things. So for example, in Piggy Park, the gentleman's refusal to serve blacks was, from his point of view, based on religion, expressive. It was also conduct, and it was also based on status of the people that he refused to serve. If you refused to cater to an interfaith marriage or an interracial marriage, that is conduct. It is based upon status, Protestant, Catholic, whatever your race, same sex, etc. But it also can be religious expression, and it can be status. Now, the paradox of the case actually originates in the stipulations. 2016, 7 years ago, the stipulations. And the stipulations do say that Laurie Smith does not normally discriminate based on sexual orientation. She would serve a gay client who wanted to do a business website, maybe, we don't know. But she doesn't want to express anything that is contrary to her religion, and another stipulation says her religion is based on the Bible, and stipulation number 75, for the record, is that she believes the Bible requires marriage be a lifelong commitment between one man and one woman. Majority consistently gets this wrong in terms of what she actually believes in. It's a lifetime commitment, yes, one man and one woman. So it's not exactly clear, how far she goes. And the court's decision, or maybe even just the court's debate, the conduct, status, message debate within the court is kind of destabilizing because it relies ultimately on a characterization game. And it asks Laurie Smith, as the owner, what she wants to make of it. She can go in any number of different directions, and let me just give you a few of them. So say Laurie Smith is asked to do, can we do an anniversary website? A lot of people do that. Gay people, probably not. What about birthdays? Maybe, but maybe not. What about funerals? What if you have a funeral and you have a bereaved spouse, or you have children raised in the relationship? Maybe not, you don't know. It's kind of a law-free zone. And if she's read Romans 1:26 through 27 recently, she probably is going to discriminate against any gay and lesbian people on a wide array of things, not just marriages. But you don't know. The opinion sort of gives her a carte blanche. What if she, in y'all's brief, Erin, she relies on Matthew. Matthew is a great book of the Bible. It has many words of Jesus Christ, our Lord and Savior. But if you actually read Matthew, read it. Read Matthew 19:9. Jesus Christ never condemns same-sex marriages. He never condemns lesbian couples. This was not an idea that he would have been familiar with. He does condemn adultery, and he defines it, he with a capital H. He defines adultery as any situation where a man divorces his wife not for her infidelity and remarries. On 532, an adulteress is a woman who, while her husband is still alive, leaves him and marries another man. You see where I'm going with this? If you actually believe in the Bible and the literal words of Jesus Christ, after whom the religion is named, then it seems to me that you ought to also discriminate against a lot of remarriages. 21% of remarriages, both spouses have been married before, and obviously a higher percentage, one spouse. I don't know. Remember, she says lifelong. Lifelong means no divorce. And what about interracial marriages? There are still many Americans, hundreds of thousands of them, maybe even millions, but probably hundreds of thousands of Americans, which believe still that interracial marriages violate Noah's curse or even the Tower of Babel for some bizarre reason. And then what about this? The court says that we're only going to spring from anti-discrimination laws what they call creative professionals, and that they can exclude almost anyone, which I don't believe, but that's what they say. Well, okay, say you get a family values home builder. We believe in building houses that are like the house of the Lord. We have a particular view of the Bible, and we're not going to build houses for lesbian and gay families, or any kind of families that we consider non-traditional. What about the non-binary clothing store? The non-binary clothing store might say, we don't believe in gender stereotypes, and the Southern Baptist Convention has repeatedly endorsed gender stereotypes. We're not going to serve Baptists in our store, only progressives. What about a progressive hair salon? Also discriminating against people who adhere to faith traditions that have marriage or other views that are antimony to the LGBT community, funeral homes, etc. You might say, funeral homes, how's that expressive? Well, Justice Sotomayor cites a case where a funeral home refused to do a headstone that had a message on it that was of a bereaved spouse. A lot of these things can be expressive. And remember, do not forget, I use the word sale. What is selling? It's expressive. What is a website? It's expressive. And a website can sort of lay out, here is our philosophy. Okay, that's the second point. Now here's the third point, and that is there's a danger of balkanization. And remember, the victims of free speech can be religious minorities as well as sexual or gender minorities or racial minorities, etc. There is a danger of balkanization, and that is a stratified market with minority religions, minority races, minority sexualities, consigned to second-class market situations, or just self-segregating into their own markets. We've seen that before. That's quite possible. Now, personally, I don't think that's realistic because the expression, status, conduct trichotomy can always be flipped. It's completely malleable, I think. So take a case that was not mentioned yet, the Fair case. That was the case where the federal government went after the universities, including Yale, and said, look, you people are not giving Cadillac treatment to military recruiters, which means advertisements, which means housing, which means linking them with students, et cetera, because you think that they discriminate against LGBTQ people. And the universities said, this violates our free expression. The Supreme Court, I think it was unanimous, one justice not participating, said, well, but no, they are regulating conduct, and the speech stuff is just incidental. Now, by the way, the record in that case, the justices need to read the record more carefully. The record in that case established that the motive for the Solomon Amendment was anti-LGBT. The Solomon Amendment was not viewpoint neutral. It says this does not apply to religious universities. And Yale had a letter, because Yale said, look, we'll accommodate your folks, but just not in the same way. The Department of Defense, this was in the record, the Department of Defense wrote to Yale University saying that's not acceptable because that would send a message to your students that we are not as good an employer as the rest of them. The Supreme Court upheld that. So here's the danger. For the time being, the anti-discrimination sort of has an elastic allowance only basically for anti-gay discrimination. Are they going to overrule Piggy Park? Well, they didn't in this case. I don't think they would dare. So private clubs, anti-gay, Dale, sure. Private marches, private speech, Hurley, sure. Private businesses, if you can sort of launder yourself into an expressive business, sure. But if it's a public entity, the Supreme Court has now held twice that public entities can, in Fulton, the Philadelphia Charitable Charities case, which was a state program, it was not private, it was a private group in a state program, it says the Free Exercise Clause, First Amendment, requires you to discriminate, and in Fair, it upheld a blatant discrimination by the federal government. So, my concern is at Yale, we're actually interested in the rule of law, and we're interested in the way in which law can be malleable and destabilized, which I think this decision does do. But we also are very concerned that the Supreme Court is sending its own expression, which they're entitled to do in terms of speeches. Their own expression is that we now have a constitutional caste system, particularly since 2017, where the ordinary rules are not going to apply in cases where LGBTQ people are complaining, but we're not going to overrule our sex discrimination cases like Roberts, that was JC's, Piggy Park, that was race, religious discrimination, they're not going to overrule those cases as well, as we see in the next panel. So that's my concern.
Thank you, Professor. We're going to We will shift gears now over to Erin to talk about Groff.
Thank you, Judge Duncan, and to my fellow panelists in the Federalist Society. It's great to be here. I had the privilege of arguing Groff and representing Gerald Groff, along with the great team at First Liberty Institute and two other firms. And I'm not going to go through all of the facts and all of the precise holdings and subholdings of Groff. Most of you are pretty familiar with it. Judge Duncan gave an overview of it. I also wasn't going to quote the Bible, but I can't let Professor Eskridge out-quote me on the scriptures. So I looked up the relevant verse. Remember the Sabbath day to keep it holy. 6 days you shall labor and do all your work, but the seventh day is a Sabbath to the Lord your God. That's Exodus 28 through 10. That was at issue in our case, as Judge Duncan said. Mr. Groff believed very firmly that he should not work on the Sabbath day, which he celebrated on Sunday. And what you need to know about the holding, I can tell you in 2 sentences, because I'm going to shift gears a little bit after that. But the key language there is in Title VII, which requires an employer to accommodate reasonably the religious belief or practice of an employee, so long as that can be done without an undue hardship on the conduct of the business. And the Supreme Court, in a case called Hardison, had interpreted that to mean anything more than a de minimis cost, a very low standard for allowing employers to deny undue hardships, to deny religious accommodations. So the question in Groff was, should that standard be overruled, revised, clarified? And the court said, yes, it should. And in fact, the standard should be interpreted consistent with the plain language of undue hardship on the conduct of the employer's business, which the court said means employers must accommodate unless there would be a substantial cost to the overall business. A substantial disruption was another formulation that they used. So why the shift? The court didn't technically overrule the Hardison case. Why the shift from a very non-textual interpretation to a faithfully textual interpretation? And I think that the key has to do with the Lemon test. We all know about the Lemon test from a 1971 case where the court set out a 3-part test for when a statute violates or a government action violates the Establishment Clause. Does it further religion? Does it have the purpose of furthering religion? And does it cause the government to become entangled with religion? And then later we get the Justice O'Connor gloss, would a reasonable observer think that the government action is endorsing religion? Well, that was very much in the background in the Hardison case. But in a case we all know called Kennedy versus Bremerton School District, also known as the Coach Kennedy case, the court said, we've abandoned Lemon. The court hadn't really abandoned it up until that point, but once they said they had abandoned it, they'd abandoned it. And they said, now we are looking to text, history, and tradition, which the court doesn't tell us exactly what that means in that case, but the arguments that have typically been made for text, history, and tradition under the Establishment Clause would require a showing of something like government coercion or government taxation to benefit religion. So ideas of burdens and furthering religion and psychological discomfort and that sort of thing are no longer in play under the Establishment Clause. So that's where we came, where we found ourselves between Hardison and Groff. Now, we've had plenty of discussions on panels like this at the Federalist Society and elsewhere about what Lemon now allows under the Establishment Clause. You know, are we now allowing school prayer? What other types of religious displays are we allowing now that Lemon is gone and something more like a coercion test is in place? But I'm going to focus today on how abandoning the Lemon test frees up the court to interpret statutes according to their terms, and with using last term's decision in Groff as Exhibit 1. And I'll perhaps touch on some other examples that may be coming down the pipe in future comments on this panel. The idea of burdens on third parties has long been a central concept of the Establishment Clause inquiry under Lemon and its progeny. Think about the RFRA case of Hobby Lobby. Much of the debate in that case was not so much centered along the RFRA test itself, which is of course a very demanding strict scrutiny test. The idea or the objection to Hobby Lobby's policy of not providing contraception coverage to its employees was that this would place a burden on third parties and therefore would run afoul of constitutional values. There are interesting cases between Hardison and Groff like a Connecticut statute that actually required all employees to be able to have the ability to take off on Sunday, not any other day, not any other religious accommodation, just Sunday. The court said that violates Lemon. That burdens employees who don't celebrate that religion and will have to pick up extra work, and that burdens employers who will now have to deal with that extra day off from work. So in Hardison itself, there was a lot of briefing on the Establishment Clause. In fact, that was one of the questions on which cert was granted in Hardison. And it was sort of the ghost in the machine behind the opinion in Hardison. Everybody always wonders, well, how did the court get it so wrong? Undue hardship obviously does not mean more than de minimis. And other than being a 1970s decision where the court didn't really look at text very much, the real reason was this Establishment Clause backdrop to the case. And the arguments and the concerns that were raised is if we really interpret Title VII according to its terms, undue hardship's a pretty high standard. An employer is going to have to take on a fair amount of burdens onto itself in order to accommodate religion. And that's a burden on a third party. That's always been seen as an Establishment Clause issue under Lemon. And who's going to pick up the slack for the extra day of work or the hour of work? Now, usually it's not actually picking up the slack, it's just shifting around time. But who's going to take the less desirable shift? Well, it may be somebody who doesn't have that religious belief, so that's a burden on a third party. So I think the court during that time was quite reluctant to interpret Title VII according to its terms because it was laboring under this misconception of the Establishment Clause that was put forward in Lemon. In fact, if you listen to the oral argument in Hardison, it's fascinating. It's just a peek into another era of when Lemon was just fresh off the lemon tree. And Justice White is just, well, what if I want to go watch my kid play football on Saturday? And that's my religion. That's not a religion, but that's almost a religion to me. Remember he was a great football player. Isn't that discriminating against me to let somebody else take Saturday or Sunday off because of their faith? And that's how it was looked at. And so that's where the court, I think, reached the result that it did in Hardison. After Hardison, naturally, there was a lot of legislative debate about fixing the unduly low standard in Hardison and perhaps getting it up to something more consistent with the plain text. But there was testimony in the congressional hearings that said, well, if you increase the level of burden that employers have to bear, then you will be running afoul of Lemon. And Congress never passed a statute like that. We don't know if it was because of Lemon. We don't know, but there's a lot of reasons legislatures do or don't do things. But that was very much in the debate. Interestingly, we come to Groff, and the court finally grants cert on a case after 50 years that requires it to address the question of what undue hardship means and whether it should adhere to its formulation in Hardison. And lo and behold, the Solicitor General doesn't even defend the de minimis test. It does not cite Lemon, of course. Lemon's been now abrogated or abandoned in Kennedy. And there's not hardly any discussion of burdens on third parties as a reason to not interpret Title VII according to its terms. There's discussion of burdens, but it's in the context of what the words of the statute means, not in terms of what the Establishment Clause means. So what changed, of course, to allow Groff now to interpret Title VII according to its terms? Well, Groff tells us. It's got a great discussion of Lemon being, now it's called abrogated. Lemon has moved from being abandoned in Kennedy versus Bremerton to abrogated, so I think that's finally maybe the nail in the coffin. And Justice Alito, in his unanimous opinion, says, we might have misinterpreted, or we might have used this loose language in Hardison about de minimis because we were worried about the Establishment Clause. But now we're not worried about that anymore. We can interpret this according to its plain meaning. And the court pulled out the 1970s dictionaries and looked at what undue hardship means and says it means a substantial cost on the conduct of the business. So the court says we don't need to overrule Hardison, we're just going to clarify it. If you want to know more, read the opinion. It's interesting from the perspective of one who litigated it, but the court says the test was not found in our holding, which we stated at the end of our opinion, where we said we hold de minimis. It was found in footnote 14, where we said substantial cost. So we'll take a win however we can get it. But it was an interesting way the court got to a unanimous decision and did not have to use the word overrule in a statutory context. But there's nothing in the opinion about concerns about the Establishment Clause bearing on the interpretation now, and there's nothing about burdens as a constitutional matter. So, of course, with Lemon being now reinterpreted to basically deal only with coercion, we don't have any government coercion involved here. We don't have any taxation being involved here, and so the Establishment Clause doesn't come into play. What else happened? I think something else very important happened that I sort of dug into as I was preparing to argue this case. When Hardison was decided back in the 1970s, there was only one statute that required employers to provide accommodations for some protected characteristic. And so, in that sense, you can understand why the court got it wrong. It looked like there was this targeted favoring of religion. In the time between Hardison and Groff, Congress enacted many accommodation statutes. Probably the most famous and relevant one was the Americans with Disabilities Act, which used the exact same language, reasonable accommodation, absent an undue hardship on the conduct of the employer's business. The Pregnant Workers Fairness Act passed in 2022, just in time for Groff. The USERRA Act involving accommodating veterans, and probably the most burdensome accommodation statute, and I don't use that pejoratively, but the one that probably has the most effect on employers is the Family and Medical Leave Act. Anyone can take 12 weeks of family and medical leave. It's not even based on a protected characteristic, and the employer just has to find a way to deal with it. So it's become ingrained in our culture that within the workplace, employers and employees are going to work together to accommodate one another's protected characteristics because we think it's important for everybody to be able to work in the workplace. So now, with that backdrop, it does not seem anomalous. Nothing seems unconstitutional about requiring employers and employees to bear one another's burdens so that religious workers can fully participate in the workplace. So where does that leave us? Under Groff, the test is now that the employer must show substantial cost to the business or substantial disruption. The second holding of the court is also important, and that's where the court does turn to the issue of burdens in the context of the statute. And the court says that burdens on coworkers are not enough. And the court says we got to look at the text of the statute. The statute says undue hardship on the conduct of the employer's business. So if an employee has to pick up the shift or shift around the time that he or she works to accommodate a religious worker, then that's not going to be in and of itself an undue hardship on the business. The employer will have to come forward and adduce evidence of the effect on the business as a whole. Is the job not getting done? Is it hurting the bottom line? Is it disrupting the morale in some material way? And again, that was based on an interpretation of the statute. Not a single word about we're interpreting it this way to comply with the Establishment Clause or anything like that. So the implication is, of course, some coworkers are going to have to bear some burdens, and yet nobody says anything that has any concern for the Establishment Clause. Another interesting issue that's open after Groff, partially open at least, is what about unionized workplaces? So in a unionized workplace, you have a collective bargaining agreement. Mr. Groff's workplace was a good example, the Postal Service. It simply said in his union agreement that Sunday shifts will be assigned on a rotating basis. And the Postal Service said, oh, we can't give you a religious accommodation. It's a pure rotating basis, and if you get an accommodation, we'll have to breach our collective bargaining agreement. Well, Hardison was open to the reading that any accommodation that required an employer to alter a collective bargaining agreement would be per se an undue hardship. That's what the district court held in our case, which of course would mean that employers and unions could just bargain away accommodation rights by not including them in a CBA. Justice Alito's unanimous opinion, I think, helpfully, if perhaps implicitly, solves that problem. It interprets Hardison very narrowly to only be about seniority rights. It says only if the employer would have to violate a seniority right in a collective bargaining agreement will that be an undue hardship. And the reason that makes sense is because Title VII has a special carve-out protection for seniority rights in collective bargaining agreements. So we now read Groff to say any alteration or accommodation that would be required that would violate, quote unquote, other provisions of a collective bargaining agreement that don't have to do with seniority, that's not a per se undue hardship. Instead, it's going to have to be judged under the substantial cost or substantial disruption test going forward. And again, that I think shows how the shift has made its way from being very worried about accommodating, from I guess being worried about imposing costs on coworkers, and more in favor of accommodating the religious practice of individual employees. Incidentally, that issue is going to probably be resolved on the Groff remand because, as I mentioned, the district court misinterpreted Hardison to say that it would be a per se rule, that any time a CBA needs to be altered, it would be an undue hardship. We think we'll win on that now under Groff. I think I will stop there. I think there's some future issues we can discuss on the next round about other statutes that the court is now free to interpret according to their terms without being worried about violating the Establishment Clause now that the Establishment Clause is properly understood, but I'll reserve my comments on those.
Thank you, Erin. Last but not least, Adam.
Thank you, Your Honor. It's just, first I want to start by expressing my thanks to the Federalist Society for inviting me to this incredibly distinguished panel. It's really an honor, and I truly appreciate the Federalist Society's commitment to the free exchange of ideas. So I'd like to talk a little bit about a couple of questions that I interpret Groff to have left open. Groff was a unanimous decision, and that's certainly a testament to the outstanding lawyering of my colleague on the panel today. But as one might expect from a Supreme Court that's sharply divided on issues of religious liberty, in a unanimous opinion, there's a number of issues that weren't decided. So I'd like to focus on two in my remarks today. One is the issue of coworker burdens that Erin mentioned, and the other is to what extent an employer have to pay cash out of pocket to hire new employees to ensure that they're fully staffed. The opinion does use a substantial cost standard, but the question is, what are substantial costs in this context? So let me start off with the first question about coworkers. So the decision in Groff makes crystal clear that the fact that a coworker is merely offended by an accommodation is not a reason to deny it. So if an employee seeks an accommodation that might allow him to, for example, wear a beard, the employer cannot deny it because some coworker doesn't like looking at beards or thinks it's unfair that the other employee wears a beard and he doesn't, or is just an atheist who hates religion. Those are not reasons to deny an accommodation, and Groff makes that clear, and properly so. I actually am surprised that any courts ever went the other way on this, but apparently there were some horrible decisions of that nature in the past. But what I construe Groff to leave open is the question of tangible harms on coworkers. So just concretely, suppose you've got two coworkers and they're equally senior and the employer would like them to split Sundays. But one employee says, well, I'm religious and I can't work on Sunday. Does the employer have an obligation under Title VII to say, well, I'm just going to force the other employee to work every single Sunday, even if it's against his will? The other employee may have very good reasons not to want to work every Sunday. Maybe he wants to spend time with his family. Maybe he wants to go to soccer games. I don't construe the Groff opinion as having resolved that question. At the end of the decision, the Groff opinion puts various options on the table for accommodations in that situation, like voluntary shift swapping, incentive pay. But I don't construe it as deciding one way or another the question of whether the employer is required under Title VII to coerce the reluctant employee, if he is not willing to swap shifts voluntarily, to work when the employee doesn't want to. In my opinion, the answer is no. I don't think that Title VII should be interpreted to require the employer to force the unwilling employee to work every Sunday to accommodate the religious employee's religious practice. And I guess that's for a few reasons. First of all, the statute talks about the undue burden to the conduct of the employer's business. And I think that if the employee is recalcitrant and files grievances or quits, which are some of the facts that actually occurred in the Groff case itself, I do think that puts an undue burden on the conduct of the employer's business. I think that respect towards employees, treating them equitably, ensuring that they don't feel like they're discriminated against, is part of the conduct of an employer's business. I think most employers would say that. But more fundamentally, Title VII is an anti-discrimination statute. The way it's set up is that the employer is not permitted to discriminate on the basis of religious practices. You can't fire someone or not hire them because of their religious belief or practice. And then, as an exception to that principle, is the undue hardship exception. So I accept that if an employer has a facially neutral no beards rule and is so Procrustean about it that they just fire any employee who wants to wear a beard for a religious reason, I accept that's a form of discrimination against the religious employee. Again, even if it's a facially neutral rule, that policy reflects such hostility and such unwillingness to tolerate religious diversity in the workplace that I think it's sensible to consider that a species of anti-religious discrimination. But I think it's a little different when we're talking about an employer saying, hey, employee, you have to work every single Sunday even if you don't want to. That does sound like discrimination going the other way in ordinary English. I mean, think of it from the employee's perspective. I don't want to work every Sunday. I have to do it because I'm not religious and someone else is. Like, in ordinary English, that is discrimination on the basis of religious belief. And from my perspective, to paraphrase the Chief Justice, the way to stop discrimination on the basis of religious belief is to stop discriminating on the basis of religious belief. And one final point on this. I think that we have to interpret Title VII consistent with traditional conceptions of religious liberty. I think historically it's been religious freedom has been a negative liberty. The government stays away from someone if they want to practice their religion. That's certainly compatible with a case like 303 Creative, where the website designer simply wanted to be left alone and create websites according to her faith. It's also consistent with the Hobby Lobby case, where again, the employer said, look, we're a religious employer, we just don't want to offer contraception in our insurance policy. Leave us alone, government, let us hire who we want. But it's a little bit different when you're talking about the government requiring a reluctant employer to require a reluctant employee to work days the employee doesn't want. That strikes me more as using government as a sword to impose religious beliefs on a reluctant person rather than using religious freedom principles as a shield to ensure that someone can practice according to their faith without government interference. So I'd like to talk about one other issue, which is the question of how much money the employer really has to spend to comply with Title VII. So for example, just concretely, in the hypothetical where there's the two employees who want to split Sundays, one accommodation is to say the employer can just hire another employee and pay the cash out of pocket. And the question is whether, under the Hardison case, the employer has to do that. Well, the opinion says substantial cost, and I don't really know what that means. And then it says that, in applying that factor, you have to consider the size and operational cost of the employer. Okay, so the employer in Groff is the federal government, the wealthiest employer in the country. Looking at its balance sheet last year, it earned minus $1.7 trillion last year. So surely the government can afford, Lord knows it wastes money on a lot worse. Surely it could have afforded to hire one more mailman. Right? But there's a question of whether, is that substantial? What about Walmart? The opinion calls out Walmart. It says Walmart earned $11 billion in profits. There it criticized Walmart for not allowing voluntary shift swapping, but suppose the remedy in one case, the accommodation is just hiring one more greeter for $7.25 an hour. Walmart would never notice that new hire. But the question is whether Walmart should be required under Title VII to just hire a new employee to ensure there's full coverage on Sundays, even if that requires paying out of pocket. And I don't really think it does. But first, let me just register my dissatisfaction with the substantial cost standard, because I have no idea what that means, in these hypotheticals. So that may seem like a little bit of a low blow, right? Like the law tolerates substantiality standards all the time. Right? Substantial cost, in other contexts, substantial compliance, substantial risk. And it's like the easiest thing in the world to say, well, where do you draw the line, right? The law tolerates a certain amount of ambiguity, and that's okay. But it just feels a little different in the context of Title VII, because the problem is you're measuring this cost standard against the value of someone living according to their faith. When you're asking whether there's a substantial cost, what you're really asking is you're asking to measure the cost on the employer with the employee's ability to practice their religion and work at a particular job. So you're basically saying is, how much is it worth in the abstract? How important it is? How much money are we willing to spend to allow this employee to work and still live his life according to his faith? And like, how do you measure that? And it's almost a little bit even worse than that, because in the Groff case, the employer was the government. In most Title VII cases, it's a private employer, right? And so what Groff is essentially commanding private employers to do is to do this measurement, is telling, hey, private employers, you've got to measure the value of the religious practice of your employees and decide, is that value substantial? And then, if you get it wrong, there's a lawsuit that's filed, because of course there's a private right of action in Title VII, and then a court is going to make the same determination. And I just don't even, it's just incommensurate, the value of someone, living according to their faith with how much money you're spending, and that's why I sort of dislike this new standard. But I would also like to just say a few words about the Establishment Clause. Now, I know that when people hear Establishment Clause, it causes, a lot of people's eyes to roll, right? There's those neurotic atheists getting traumatized about seeing a Christmas tree again. And, there's no doubt that even as someone who is somewhat sympathetic to Establishment Clause claims, there have been some excesses over the years. And in fact, the claim in Hardison that my colleague alluded to was one of those. The argument was made that any statute that required religious accommodations had the effect of advancing religion, which is one of the three prongs of Lemon, and therefore was unconstitutional. So, I do not mourn the death of Lemon. Almost no one does. But that doesn't mean that, Establishment Clause claims always lose. I mean, it's still there in the Constitution. It still does mean something. And, we all know the boy who cries wolf parable. When I was a kid, at the end of the parable, the wolf actually ate the boy. I'm told by my son that, now in school, they actually just see the wolf and then, go home, which I think misses the point of the parable. But anyway, it's a gentler era today. But anyway, sometimes eventually, after a lot of weak claims, you get a stronger one. And I think that under an interpretation of Title VII that requires public employers to essentially hire a new person and spend money out of pocket to accommodate religious belief, I think that presents an Establishment Clause problem, not under Lemon, not under the living Constitution, but under, the dead Constitution, the 1787 Constitution. And just thinking this through, so, Justice Thomas, for instance, has offered a persuasive case that the Establishment Clause shouldn't be incorporated against the states, but this is a federal statute, so that's not an issue at all here. Number two, there's many arguments that have been made that the Establishment Clause, applies a coercion standard. Having hurt feelings about seeing someone praying is not an Establishment Clause violation. I accept that. But there's definitely coercion in Title VII as applied to private employers. The government is saying, if you don't pay money out of pocket to hire this new person, you are punished. You pay fines. The EEOC is going after you. That's coercive. I mean, I bet some people in this room probably don't like Bostock. Bostock is definitely coercive. It's forcing employers to do certain things. Well, so is Title VII as applied to religious employees as well. Then there's a question of spending, right? There's many Supreme Court cases that say that you can tax people as long as the money is spent neutrally, if it's spent on both religious and non-religious institutions in neutral terms. But Title VII definitely doesn't do that under an interpretation in which employers must earmark funds specifically for purposes of religious believers. And finally, one more word about history and tradition. Let's face it, all of us in this room determine history and tradition on Wikipedia. If you look on Wikipedia and you research this for a few minutes, you are not going to find examples of sort of old statutes from the early republic imposing, sort of requiring employers to spend money to advance religious practice in this way. You'll definitely find examples of things like legislative prayer and displays of religious symbols and things like that were struck down during the period Lemon was alive, but laws under interpretation of Title VII, a law that would impose this sort of coercive spending requirement on employers, I don't think you would have seen that. And that's why I'm skeptical of a very broad understanding of substantial costs. Thank you.
Thank you, Adam. Well, I've been a bad moderator, and I've let the panelists run on, and I take the same approach to oral argument time, by the way, in the Fifth Circuit, if you're ever there. But I was just so entranced with what everyone was saying. It was so good. And so I will risk letting people respond because I know there's lots to say. And so take it away, Erin.
I will be brief. So just a couple of counterpoints. First, as to Stewart, there's no dispute.
This is Stewart.
Yes, Stewart. Actually, I think Stewart is Stewart. The question is whether Mike is Mike.
I see.
But as to Stewart and Mike, there's no question that Lori received that email from an outside source. There's also no question that she would have put herself in peril had she investigated that claim. Again, just look at Jack Phillips down the road. And Jack Phillips is relevant to my second response as well. Professor Eskridge recommended, I think, something good here, that maybe the commission take a look at its own statute. We would be delighted if the commission and the Colorado courts would look closely at COTA, because Professor Eskridge is correct. COTA says the discrimination has to be because of a protected characteristic. But in the third iteration of Masterpiece Cake Shop, after the state has yet once again gone after Jack Phillips, and then when that case got kicked, been sued in civil court under the same statute, the trial court found two critical things as finding of fact. The trial court found that a gender transition cake was inherently expressive. It was celebrating a gender transition. The trial court also found that it was message-based and that Mr. Phillips would not make that cake for anyone. Despite finding both of those things, the trial court found that this violated COTA. So I love Professor Eskridge's recommendation, but the Colorado courts so far have closed that door. The last thing I'll say, to take a shot at our alma mater, law might be malleable at Yale, but to quote a Harvard law professor who we're all familiar with, Justice Kagan, there is value in drawing lines, especially when you're talking about the First Amendment. Line drawing is a part of every free speech case. The question is whether something is speech or not. That's something that is not unique to this context. And she makes the really good point that if you don't evaluate that, if you don't draw lines and determine whether something is speech and protected or whether something is conduct and not protected, then you are going to allow the government to do precisely what Colorado sought to do here, and that's to silence someone based upon their viewpoint or to compel them to speak contrary to their conscience.
Please, and then you go ahead, say whatever you like, and then I have a follow-up.
Oh, whatever I like. Okay. Stewart, I appreciate Ms. Smith's position, but if you put it in a Supreme Court brief, I think the lawyers need to figure out whether Stewart was really someone who was going to complain. And the fact of the matter is that he was not. I think we're actually on agreement. I would go further than you, though, Professor. I do think that Colorado needs to pay careful attention to its statute. But I also think two further things, and that is that civil rights commissions need to take very seriously their conciliation duties and their duties not to go hog wild on remedies. It does seem to me this relates to the discussion y'all are having, that you should not impose substantial costs on small businesses that are doing it on principle, even if you think the principle does violate the statute and is not protected by the First Amendment. I think it's egregious, the remedies that are sometimes issued against small business people. And I also do think that legislatures, unfortunately, I think the Colorado legislature, the Congress, et cetera, ought to revisit some of these statutes. The Gorsuch opinion has an implicit criticism that maybe public accommodations ought not to be so broadly defined. Well, okay, I think that's worthy of legislative consideration, particularly in light of some of these cases. I think remedies need to be maybe more tailored, and the legislature can certainly send signals through revisiting the statute. And frankly, let me cite a church, the Church of Jesus Christ of Latter-day Saints. I don't know if we have a lot of Latter-day Saints in the audience. One of the great statutes passed in the last 10 years is the Fairness for All statute that Utah passed in 2015, expanding their anti-discrimination law, not in public accommodations, but for employment and housing, and creating religious allowances by statute, such as we see in Title VII already. Now, finally, I do believe that the Yale people are in one mind about drawing lines. Yes, I'm with the professor on drawing lines. I would draw lines the way precedent draws lines. And that is, there's no Supreme Court case where the Supreme Court has held that sales, advertisements, sales talk, etc., is protected by the First Amendment against anti-discrimination laws in a blanket or broad way. That is the holding of Piggy Park. It's holding, I think, of Runyon versus McCrary as well, which I didn't mention, and probably of Heart of Atlanta too, and maybe McClung. So it's a holding of a whole variety of cases, and it's different from these other cases. And I might add that we go back to Barnett in 1943 or thereabouts, 1940s sometime. When Barnett was decided, the First Amendment gave no protection to commercial speech. You want to talk about a living Constitution? That's the living Constitution. And y'all, many originalists out there, can you raise your hand, originalists? Huh? Why don't you read the Gorsuch opinion and see how much original public meaning evidence he adduces for his ultimate holding? I'll tell you what, the short answer is pretty much none, although I think he does wave at the original meaning of the First Amendment, and certainly the text of the First Amendment. But remember, speech is contradisposed toward conduct and status, and the First Amendment original public meaning, it cites Madison, if I remember correctly, but not quite on point. The main on point stuff that he relies on are Supreme Court precedents, mainly precedents, in the last, say, 60 or 70 years. So this is truly a living Constitution, but it's a living Constitution that I think draws the lines in a really odd way.
Thank you, Professor. If I may, I was going to follow up on the Piggy Park point. I thought the edgiest thing that Professor Eskridge said, and that Justice Sotomayor says in her dissent, is that this opens the door to overruling a case like that. Do you have a view on that? Do you want to say anything to that? Or, well, actually, you said something already.
Oh, okay.
And that's good.
But both of us.
But did Erin have a view? I didn't think you responded to that, or did you?
So no, absolutely not. I think that the majority goes out of its way in 4 or 5 places to talk about how this is about speech. It is about, it's not about a cell, and I think if we're going to talk about original meaning, I think that there's no case throughout the history, certainly none that were offered by Colorado, that allows a government to compel someone to speak contrary to their belief. That's just something that has not happened until recent times. And for that reason, I think Piggy Park, Runyon, all of these cases, Heart of Atlanta, are absolutely distinguishable.
I would disagree on the line drawing there. There are many cases where the Supreme Court has upheld government compelling you to speak against your belief. Many of them are libel cases. You might really believe something that is untrue and libelous, but you're going to be held accountable for that. Fraud, this is sales. A lot of people, the best fraudsters, we see this in politics, don't we? The best fraudsters are the ones who actually believe their own fraudulent claims. That can be held liable based upon the First Amendment. And moreover, until the 1970s, and really much more the 90s and the new millennium, you could say all sorts of things you believed in commercial speech, and the state could prohibit it. And it still can prohibit a lot of that stuff. Like if you try to sell a drug that's actually harmful, but you believe it's not, you can be held liable for that. Now, in Piggy Park, I think we're at one. Of course they're not going to overrule Piggy Park. Is it because of principle? No. Piggy Park was a speech case. It was a case just as sincere as Laurie Smith. Morally not as admirable, but just as sincere. I wrote a whole article on this. I'll give you a copy called Noah's Curse, which does document religious, either one of you can have it, the faith tradition.
This is a real article.
It's a real article.
Like Stewart.
No, it's a real article that I'm a Presbyterian. My own denomination, Southern Presbyterians in the 19th century, believed that the word of the Lord required racial segregation and required barring interracial marriages. And many religions continued to believe that through much of the 20th century. though that's been muted, I think, since the civil rights laws of the 60s.
You were
Yeah.
a Southern Presbyterian, and you were from the South, I would guess, by your accent.
Yes and yes.
Where are you from?
Well, West Virginia,
We'll
which
see.
many of you all would not consider true South,
Well,
but we were South.
I'm
Right.
from South Louisiana, so I would consider you a Yankee. But,
Well, if you want to call me names,
but I am.
if you call me names, I will, to great Jesus Christ taught us, I will turn the other cheek.
I will, and with that, it is refreshing that Yale would hire someone who points his finger at people and says, y'all. So
Y'all
great-
originalists.
I'm
but,
grateful for that.
But they're not going to overrule Piggy Park because it's a race case. And remember, my point is that it is completely flippable. If you want to emphasize the status and conduct, then you uphold Piggy Park. If you want to emphasize the message, then you don't. And the racism, or however you want to term it, message in Piggy Park is unacceptable. And you can legally launder that in a lot of different ways, but it's unacceptable today. But it's not unacceptable to harbor, anti-gay things, right?
If Professor Eskridge were in my court, I would have given him a lot of extra argument time, and you used your time well. Let me let Erin, if you have any, and Adam, if you have any final comments. I must say I was intrigued by Adam's suggestion about the Establishment Clause from I guess a certain interpretation of the undue hardship. I don't know if you want to speak to that or
Yep.
anything else.
Yeah, I appreciated Adam's thoughtful comments on that too. And I think one way to look at this is, I think Adam raises good questions about whether hiring an additional employee or assigning someone to work a shift he doesn't want to work would violate the would be an undue hardship under the statute. I don't think there would be a bright line rule either way on that. But I think one thing has to be clear is that it doesn't violate the Establishment Clause, because we already have the Family and Medical Leave Act. We already have the Americans with Disabilities Act. We already have the Pregnant Workers Fairness Act, which results in just think if somebody takes off 12 weeks of work, the employer has to hire somebody to cover those 12 weeks. The employer has to hire someone to do the work that if a pregnant woman is doing heavy labor, then somebody has to cover that undesirable shift. So it cannot be a violation of the Establishment Clause to treat religion on par with other protected characteristics under the statute. The only other point I would very briefly make is on whether these are going to lead to sort of unreasonable demands and a lot of lawsuits. I think so many of these questions will be resolved on the question of what is a reasonable accommodation, the other prong. And the courts have said a reasonable accommodation is not the employee's preferred accommodation. It doesn't mean that the religious person gets to give all the undesirable shifts to the non-religious people. Mr. Groff said, I'll work every single Saturday. I'll work double shifts during the week. I'll work every single holiday that's not on a Sunday. And that was a reasonable accommodation. You might end up working a graveyard shift you don't like. You're not going to get to dump all the unfavorable shifts. What it's going to lead to, I believe, having the proper standard in the statute is not going to lead to a lot more lawsuits. Hopefully it will lead to more employers and employees sitting down and working something out, which is the process that already happens under the ADA and other statutes, but has been absent because of Hardison's misinterpretation of the statute.
Adam, you've reserved 30 seconds for rebuttal.
I think I'll yield my time to the court. Thank you.
Well, I would, first of all, I want everyone to join in thanking this wonderful panel.
Well, and everybody thank the judge for his most genial, he was a moderator. He was a genial moderator, even though he did call one of the panelists names.
A Yankee. Oh, yes, I'm sorry about that.
It was in good fun.
That's all right. Well, so I have some announcements. First, the CLE thing that was announced at the beginning, same announcement as at the beginning. Second, this is more important. If you have tickets for the Anna and Scalia Memorial Dinner, this is a brief reminder that we are at a new location this year, the Washington Hilton. Shuttle buses to the Hilton will be available starting at 5:15, which is in 15 minutes, and running to 6:30 p.m., running every 5 minutes. Pickup will be on DeSales Street on the side of the hotel. Further details concerning transportation are in your convention booklet or in the app. And with that, thank you for your attention. Bye-bye. And no questions.